Hey folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. And today again we will continue with the interpretation of statute, deeds, and documents. Right? Yeah, I know we have already had a couple of lectures on this, right? But we have also done the major chunk of the chapter: the law of literal interpretation, the law of beneficial interpretation, right? The reasonable construction, harmonious construction, all these kinds of rules we have done. So in the primary rules, right, there are 6 rules in the primary rules category, and out of that we have already covered 4 of them, right? So in today's lecture we'll move ahead with the rules of exceptional construction or exceptional interpretation, whatever you say, right? But those of you who have missed out on any of the rules that I just said, right, the 4 rules that we have already completed, please go back to those lectures, view those rules, and then come back over here, right? And I'll be waiting right here, right? And for the rest who have already done and who are continuing with me throughout the session, right, for you we'll start with the rules of exceptional construction today, right? Again, over here today I'll not divide the screen into the applicability, then your features and the logics and the non-applicability and the steps and stuff, right? Today this construction, right, this rule is a little different than the other rules that we have seen, right? Those rules, if we talk about, they were basically about situations, that what do you do on the whole if such situation arise. But over here we will basically deal with the text. There are certain text, certain words that have to be construed exceptionally in certain situations, right? So we won't go by the logics, we won't go by the features and stuff. We'll straight go by what are those kinds of words and what are the exceptional situations. But if we talk about the applicability of this rule again, then understand that when you literally interpret a rule, a statute, right, and you get an absurd result out of it, that is when you call for an exceptional construction. Actually, that is when you call for all the other rules, right? And this rule will apply where any word has to be exceptionally construed. Getting the point? Right? So let us start with it and let us see what this rule has for us. And before that, I'll also tell you that the questions that you get in the examination from this particular rule, right, they're all straightforward questions. When I say straightforward, I mean straightforward. Like, you have been asked questions: explain briefly the distinction between the mandatory and the directory provisions of the statute. It's a direct question, right? Did you know the distinction? Please explain it. That's it, right? Then other question may be like stressing upon the word may, shall, or, and, right? When are they used exceptionally and stuff? These kind of questions, right? Some are directory, some are mandatory, right? Some are optional. So how and when do you use it? So I know the questions that I'm talking about would go as a bouncer because you don't know what reference are we talking about them in, right? But still I thought I would narrate the question, because once you go with the text that I'll be explaining now, you'll understand, okay, this is what the question was asking, right? So keep the question in the back of the mind, so that when you're listening to what I'm saying about this topic, right, you'll understand as to what angle to give to this topic. What are the key things that you need to remember, that you need to learn, so that you are able to score in the examination, right? So basically, if I tell you this rule, the rule of exceptional construction will be divided into 6 categories, right? So first we'll understand about the common sense rule, then we'll understand the difference between the word and or, right? We'll understand the interpretation of may, that is general and the exceptional interpretation, general and exceptional interpretation of the word shall or must, right? And then, as the question says, we'll again understand the distinction between the directory and the mandatory provision, right? And then we'll see the steps of how do we actually judge the provisions, right? So I don't think there'll be a lot of problem with that. So let us start. The first we have is the common sense rule. So in your common sense, right, when we talk about common sense, we'll talk about the common things. Like, if I have this statement written on the screen, rule of exceptional construction, what do you understand? Rule, that means you're talking about some rules. What are the rules? Those are rules of exceptional construction. That means you are interpreting something to be exceptional. In exceptional situation, how do you work? That is right. That is how you interpret it. When we talk about the common sense rule, you know, we're talking about the rule that we apply with our common sense, our common mind, our common brain, right, in the layman's term. this is what you construe, right? So in the common sense, what we basically do is that we give effect to each word that is being given in the statute, right? You read each word, you understand each word, and then you interpret. That is like more or less like the law of literal interpretation, the rule of literal interpretation that we have seen, which is the first primary rule of interpretation. But again, you must have noticed that while you are reading the text, right, and if there are certain words that do not actually form any meaning, right, that has been unnecessarily included in the statement, right? If you, like for example, if you're reading a novel, then people who are used to reading novel, and when they are reading it, they have a good reading speed, right? They automatically skip these kinds of words that forms ambiguity, that forms absurdness, that has no sensible meaning behind, right? So even this rule of exceptional construction, right, over here the common sense rule, it says that if the words that are given in the statute, that may also be eliminated at times if they do not provide any sensible meaning, right? So on the screen, eliminate words with senseless meanings, right? So that is the common sense rule. That is when you apply while you are reading the knowledge, while the novels, while you are reading any other text. But when you are reading the statute, right, you have to be a little careful with that. It's not like your normal novel or the normal text that you read day in and day out, right? So in the text, what do we do is that when we are interpreting, right, in the normal sense, if we are interpreting it, it is not giving us any meaning that is in line with what we are reading, we skip it, right? And in the term of statute, what happens is it may give you a meaning, right? I'll not say it never gives you a meaning. It may give you a meaning, but the problem is that if you inline that meaning with the rest of the statement, it gives you an absurd result, right? You know what is the intention of the statute, right? You know the law behind. Why are we trying to formulate the scheme, right? There was some problem, the legislature came up with a solution, and he said, okay, this will be the law now. And when you go through it and you interpret a word, you understand that, okay, this is defeating the law, this is defeating the purpose of the statute. There's a single word, the entire sentence is constructed very well, but just the inclusion of a single word may have devastating effects. So what do? You remove it. You read the entire sentence as if that word does not exist, or maybe you interpret it in the opposite sense, right? That is when I asked you, when I was discussing the questions with you, I told you we'll talk about the use of the word and, or, may, and these things, right? So basically what you know, and means provision 1 as well as provision 2 both, but sometimes even if it is written and, you have to apply one of them. That is an exception, right? We'll come to it, don't be confused with that, right? Slowly, silently, with the flow of the lecture, I'll explain everything to you, right? Don't be scared of that. So do you understand what is the common sense rule that we're talking about? It is the general rule that you apply while you're reading, that a class 6, class 7 student applies while he's reading, and he's not even aware that yeah, he's applying the rule, right? But we do it, that is unconsciously in us. But when you are reading the statute, you'll obviously have to be conscious with that approach. So next we have the interpretation of and or. So basically you know that the word and, right, it is normally conjunctive. Now what is conjunctive? When we say it is conjunctive, means it joins two or more provisions, it joins two or more sentences, right? When you say that yeah, I am appearing or I am pursuing my chartered accountancy and CS as well. So what do you mean? That parallelly you are going ahead with your chartered accountancy course as well as you are applying for your CS. Like you'll be appearing for both the exams, you are studying both the subjects, so it is going in hand. That is conjunctive, right? That is when you use and, right? So when you say and, that means you have to fulfill the requirements of both the provisions. Like if a provision in the statute says that you have to abide by the article as well as pass an OR, right? That you have to see if the provision is given in the article and pass an OR along with it. That means yes, you have to go by both, right? You have to refer to the article as well as you have to pass an ordinary resolution. That is and, right? Generally. And what is or generally? That you have to fulfill the requirement of any one of the provisions. Either you pass an SR, right, or you say either it's given in the article and you pass an OR, otherwise if it is not given in the article you can pass an SR. right? That means either go with the articles or the special resolution. So when it is or, then any one of it would be enough. If you have it given in the article, pass over, go ahead with it. And if it is not, then pass a special resolution, go ahead with it. Any one of the two provisions are satisfied, you are good to go. Right? That is basically what it means. But to give effect to a statute, right, to fulfill the purpose of forming a statute, the intention of the legislature, right, at some point of time you may also have to consider and to be or. Why? Because the entire statement, entire provision is framed as if any one of it will survive. Right? It will suffice, no issue with it. You either follow provision A or follow provision B, no problem. But the word used over there is and. What do you do? And you know that it is not possible for you to go by both of it. What do? You consider that and to be or in that situation. Why? And you have to be careful that, okay, with this you are not defeating the purpose of the statute. You are not defeating the intention of the legislature. Right? You have to keep in mind what is the intention of the legislature, and accordingly you can assume and to be or and or to be and in places where they are needed. Right? You just cannot go and say, oh, they say and you have to pass a ordinary resolution and take permission from board as well. We can consider and to the or, right? I'll just pass an or and move on. No, you cannot do that. Or we'll just pass a board resolution and move on. You cannot. Right? Because the situation, this statute, the intention was that yes, you have to follow both of it. You have to take the permission from member as well as the directors. Right? But in other situation when the intention was not so, and by mistake they have written and, you can consider it to be or. This is the rule of exceptional construction. Right? This is exceptional because and will never take the place of or, and or will never take the place of and. But exceptionally, you may sometimes need it. Right? So now I hope you're getting the feel, right? Now you have started to understand what is the meaning of this exceptional construction. Right? It always relates to those specific words that have to be considered in a different meaning. Right? If the ordinary meaning of the term creates an absurd result. Right? If it defeats the purpose or the intention of the legislature. Got the point? Right. The next we have is the interpretation of the word may. Right? You know the word may, we have always been using may, shall and stuff. So what is the interpretation of the word may? Right? Generally, may is a directory force, right? That okay, if you want, you may do this. If you do not want, you may not do it. We are not forcing you, right? It is directory. That okay, if you take this direction, that will help you. But we are not forcing you to take that direction. Right? But this this directory force may sometimes be construed to be as a mandatory force. That if they say you may do this, that means they intend that you have to do this. Right? You have no other option, bro. You have to do it. But generally, how do you use may? Hey, if you want, you can do it, man. You may do this, you may not do this. That means it's your choice at the end of the day. It is not on the statute. The statute gives you a choice. But if at some places that may is used such that you have no choice. You have to go with the provision. Right? Let us see how that happens. Now we will move ahead with seeing certain cases, right, where you use may as a mandatory provision. Right? For example, now you have been given certain power. Right? For example, if the court has been given certain powers, right? So the court has, if you wish, you can pass an order in favor. If you wish, you can pass an order against. If you wish, do not pass an order. Whatever, it's your wish. The order is on you. Right? Then in that case, that may becomes directory. That may becomes mandatory. Why? Because when you have been given power, right, and there is also a duty to discharge an obligation, it becomes mandatory. Right? So in short, you can say that when a subject involves a discretion coupled with an obligation. Okay, it's a discretion whatever you do, but it's an obligation, you have to do it. Right? In that case, may would be a mandatory force. It would have a mandatory force. Right? And now before this, right, we have seen the rule of beneficial construction. Right? What was the beneficial construction? That there is a law behind, right, and there was some mischief that was taking place, and then the legislature came up with a statute, came up with a law which intended to actually suppress that mischief right, and advance the remedy behind. So you say, okay, like for example, in the same street, right, we took an example of the street in US where the prostitutes used to disturb the people, right? So the court says that you may have to shift away from the street. What does that mean? You may and you may not. Listen, we are telling, please, you may. If you don't want, you can stay on the street, no problem with that. Is that what the court wanted to say? No. If that is a statute passed, is that what the legislature wanted to say? No. Just because they used the word may, you cannot say that, yeah, you have an option. No. Right? If at any point of time, when the remedy needs to be advanced or the mischief needs to be suppressed, right, then may shall be considered to be shall. That means that directory force would now be a mandatory force, that you shall stay away from the street, although we have written the word may. Why? Because your compulsion in staying away will actually suppress the mischief that you are doing, and will also bring out or will also advance the remedy for the people. So over there, if we are using may, that does not mean may. It means you shall do it. Please move ahead. Right? Next. Now, if you are bringing out a statute for somebody very reputed, somebody very powerful in the country, political power, right? The government or anything over there, you cannot order them. You cannot say, please, you shall do this. You have to do this. Go ahead. President, please sign it. No. Out of respect, out of that courtesy, right, as a matter of pure conventional courtesy, what you do is you insert the word may. That okay, if there are these documents that may be signed by the president. What does that mean? President may not sign it, then who will sign it? Right? That means the document has to be signed by the president. It is simply meaning that. But out of courtesy, they say the president may sign it. They do not say the president will sign it, the president shall sign it. Go, the president must sign it. Must sign it. Nobody can say that. Right? You cannot say a president of the country that you will have to sign it. No. You will take the document and say, sir, you may sign it. And he knows that it is his obligation to sign, right? Because if he does not sign, nobody else will. Either he'll reject it, or if he approves it, he has to sign it. If it's an ordinance, if it is something, right, that requires the signature of the president, he will have to sign it. Although the words that will be used in the statute would be may, and that is used only because of the pure conventional courtesy. Right? Now, there's one more serious place, right, where may will always be construed to be shall. Like the legislature, right, they brought out a statute to help the public in some difficulty. Right? So there was an object behind it, that yeah, they want to help the public, and then they say that yeah, this may happen, right, or this law may be passed. Does not mean that it is an option for you to pass the law. If it is in public interest, you will have to pass the law. Otherwise, that may cause potential danger to the public, to the benefit of the public, or it may result in denial of benefit to the public. So in that case, that may will be construed to be shall, and you will have to pass that law. Right? So these are some specific situations where may will never be considered to be may. Come on, if that's may and you are trying to bring out a law in the benefit of the public, then that will be considered to be a denial of benefit to the public. Right? So in that case, you cannot give an option to somebody. Right? If you are going to the president, you cannot order him, you shall do this, you shall do this, you will do this, you must do this. No. So out of courtesy, you use may over there, but that does not mean that the president has an option, that he can delegate it. No, he cannot delegate it. Right? He does not have an option for that thing. And the other thing was, if you want to suppress a mischief or advance a remedy, so in that case, you will always consider may to be shall. And the last one was, or actually the first one was, if your discretion is coupled with some obligation. Right? Are you clear with it? Do you understand what I mean to say? So now let us take some examples, right, so that it is clear with you. Till now I've just given you some vague topics on that, but now I'll give you some examples. So let us take up an example of a case, right? So there was a case between N. Nagendra Rao and the state of Andhra Pradesh, right? That was related to the collector, right? So what happened was that the collector of that state, the collector of Andhra Pradesh, he seized certain goods of N. Nagendra Rao. Right? He confiscated certain goods that he had imported. Right? Due to any reason, right? Whatever be the reason, the point is he confiscated it. And then what he decided that he would confiscate some of the goods and return the rest. Right? Let us not get deep into the case. The point is that he wanted to confiscate some portion of the good and return the rest. Right? Maybe because there were duty not paid on some portion. Maybe he wanted to confiscate 40% because Mr. Nagendra Rao paid duty only on the 60%. Right? So what happened is he confiscated the goods. So if he has passed an order of confiscating 40% of the goods, then the rest 60% should be returned. And he did it. But he delayed in returning. He held the good in his disposition for long, and at the end, one fine day, he calls Mr. Nagendra and he disposed of the goods. Okay, you take it away. This is not to be confiscated, take it away. But if you go by the section 6A of the Essential Commodity Act, right, they say that if the seized commodity, right, if it is subject to speedy and natural decay, then the collector may dispose the goods. Right, so they have used the word may over there, that if it is deteriorating goods, right, if it is subject to natural destruction, natural deterioration, then the collector may return the goods. Right, dispose of the goods means return the goods. But the collector did not, and the collector says, okay, it was me, I may have done that, I did not do it, I am not at fault. Right, but what do you think in this situation? Shouldn't it be mandatory for him? That is, if it is deteriorating, then why do you want to deteriorate the quality and the quantity and then give it to him? If it is not supposed to be confiscated, return it back to him immediately before it gets destroyed under your custody. Right? So even the court considered to read this provision, to read the statute as may to be a mandatory provision, may to have the mandatory force, that you had to return the good on time. And since you did not do it, the importer, right, Mr. Nagendra Rao, he had to face financial losses. Why? Because the goods that he had imported were subject to natural deterioration, and hence the quantity and quality both of the goods were deteriorated, and he could not sell it for the appropriate amount. Right? So he was awarded a claim against it. Right? Mr. Nagendra Rao was entitled to a claim against it along with the interest. Right? And the collector of the state of Andhra Pradesh was considered to be guilty. So I'm just not telling you a case where you have used the word may and we may consider it to be shall. No, I'm talking about a case where the court has said that this may should be considered to be shall. Why? Because it is a mandatory force. It is kind of a mandatory force. Right? It is actually to advance the remedy to the person, to Mr. Nagendra Rao. Otherwise, he would be suffering losses. Why should he suffer losses? When those 60% of the goods were absolutely correct and he should have received it so that he can store it and he can do his business, why did the collector keep it? Just because may was written over there? So I'm sorry, that may will be considered to have mandatory force rather than the obligatory force, directory force, sorry. Right? Right? So I hope this case was able to clear your doubts, and you know that yes, practically also there are certain places in the statute where they have used the word may, but that has to be construed as if it is shall. And I will not say some, there are many places where such thing has been done. Right? Now let me take one more example of one more case study. That was between Dinkar Anna Patil versus the state of Maharashtra. We have seen the state of Andhra Pradesh, now we see the state of Maharashtra. Right? So what happened is, there was a case for appointment of the sales tax officer. Right? So who would appoint the sales tax officer? Obviously it would be the government who would appoint the sales tax officer. But the rule says that the government may, in consultation with MPSC, wherever necessary, appoint the sales tax officer. Right? So in this situation it was held that the government will have to consult with the MPSC. And who is MPSC? MPSC was the Maharashtra Public Service Commissioners. Right? So the Maharashtrian government, they had to consult the Maharashtra Public Service Commissioner before appointing the sales tax officer, and they used the word may. Right? But it was held by the court that the may should have a mandatory force. It should be read as shall. Right? That would make the consultation mandatory. right? Otherwise, what would have happened if that consultation was not mandatory? The government would have misused the power, right? It would result actually in the arbitrary use of the power by the government. The government would have taken chance. They would have said, okay, it's me, we'll never consult that guy. So that Public Service Commissioner of Maharashtra, right? We say it MPSC, it is Maharashtra Public Service Commissioner, right? He would have never been consulted. He would have no value. The government would have never consulted him, right? And they would arbitrarily use the power. So that is why over here the court says that may would be construed to have mandatory force, and hence we would read it as shall. So you will always have to consult the MPSC, right, before taking any such step, before appointing a sales tax officer over there, right? Clear with it? Now I hope the condition, right, of may is clear with you. We have taken 2 practical examples as well, right? And then it is done. Next, now we move on to the interpretation of the word shall, right? And unlike may, it is opposite, right? It is generally mandatory, but exceptionally we would also take it to be directory at places. Is it? Yes, it is, right? So let us see and understand the word shall now. Now you always know, right, that whenever we use the word shall, we always mean that it is mandatory. For example, if we say that the director shall be punished with a penalty of rupees 1 lakh or 6 months imprisonment, that means that they will be charged that penalty. It does not mean that the court has an option. Okay, I think I should let you go back home, leave it. No, the court cannot do that. Why? Because the provisions in the statute, they say that the director shall be leviable with a fine of rupees 1 lakh or imprisonment of 6 months or both. You have an option of levying the penalty of 1 lakh or imprisonment or both. Over there you have an option, but you do not have an option to take the penalty away from him. That okay, you do not need to pay anything, right? You cannot relax the penalty at that point of time. That is the meaning of shall, right? But again, sometimes even this word shall will be assumed to have directory force, and that is exceptional, right? And again, like may, over here also there are few cases where we always consider shall to be may, right? So I'll discuss the cases. Number 1 is if the word is used or if the provision is used against the government, right, then the shall would be considered to be may, and that is unless any contrary intention is manifested in the statute. If the statute has specifically said that no, over here shall means shall, they have to do it, then it's a separate thing, right? For example, you also study your ISCA, right, group 2, second subject, information technology. Remember, information system, yeah. So over there in ISCA, if you read the IT Act, right, then they say that the government, the section 66, I guess, right, in section 66 you have certain provisions over there which says that the government will accept, right, the digital documents. Your return and everything shall be accepted by the government in digital form, but that shall does not make it mandatory for the government to accept it in digital form. If at some point of time the government wants you to fill up a manual form, then you have to fill up a manual form. That means it is may, right? It does not necessarily have to go ahead with the digital form. You say no, I have read it in the act over there that the government will accept it in digital form and digitally signed, so I will not give it. No, because that is again used against the government. The government always has an option. You cannot apply those forces of the statute against the government, right, unless and until the statute specifically says that no, the government will have to take it, right? Until that means in this case obviously it is not well, because at many places you go, they don't have those provisions, they don't have the technology, right? They don't have so much built up government departments in certain cities and villages over there, right? So you cannot say that yeah, all the returns I'll file it that way. No, right? But there are other situations as well where if it is said that the government will do it, that means the government will do it. It is the government's responsibility, right? Second is situations where the legislature actually demands, where the parliament demands that okay, over here we give you an option, and still they use the word shall. right? So the intention is not to have a mandatory effect over there, but their intention is to have a directory effect, that okay, we are giving an option, you can also do this. It is may over there, right? It will not be considered to be shall, although shall has been written. The word shall has been used, right? And the third is where giving it a mandatory interpretation would actually result in an absurd meaning, an absurd result, right? So in that case, you will not use it in a mandatory force. You say okay, let it be optional, because that cannot be mandatory, right? Over here also in the government case, like I'll take the same example. If you say the government has to, the government shall take it in digital form. So come on, if you have an office, the department sitting over there, he doesn't even have a computer. How do you expect him to take it in electronic form, man? Come on, you cannot do that, right? So if there are certain situations like that, then it becomes mandatory for you to interpret it as may, because you cannot apply such provisions like that. Getting the point? So those are the places where the word shall or the word must, right, that have a mandatory force always, will be considered to have a directory force, right? So are you clear with that portion of the rule so far? We still have to go with the distinction between the directory and the mandatory, and how do you actually judge the mandatory or directory provision? Which is it? How do you judge it, right? So we have steps over there. But since our timing, right, it won't allow us to go further ahead with that, because I'll take a 15-20 minutes more class on that. That is the distinction, the judging the provision, and also a question that will be discussed, right? So they'll take some time. So it's better if we take it up in the next class afresh, right? So still that, if you want, you can go back and listen to this class once again, because you need to know the examples and stuff, right? Keep that in mind, try and understand it, go flip your books, find out places, right? Discover something more, bring out new examples over there, post it in the comment box below, do that homework with you, right? And then get back to the next lecture. Okay with that? So until then, it is Abhinay Gupta signing off. Thank you and bye-bye.